Questo non si tiene nero. Si tiene.
This sitting is resumed.
Order number 11, sir. In the name of the Honourable Attorney General and Minister of Legal Affairs, to move the second reading of the Evidence Miscellaneous Provisions Bill 2019.
Honourable Member St. Joseph.
Mr. Speaker, there are some matters that, though they don't require an awful lot in the way of a speech, though the words themselves may be small in number, the change that they wrought to things that we have done for hundreds of years perhaps could nonetheless still be great. We are here today, sir, to move and hopefully to pass a relatively modest amendment to two statutes, the Evidence Act and the Interpretation Act. But by these amendments, sir, we expect to be able to embark on what I'm happy to say will be a new way of doing things in relation to how documents are dealt with in the court system. Mr. Speaker, there is absolutely no doubt that the system of the delivery of justice in Barbados has been fraught with difficulty and often delays that are inexcusable over the last decade. The system, most Barbadians feel, has gone from bad to worse. And I believe, sir, if you canvass the average Barbadian who, whether that person has a case before our courts or not, they are likely to say that justice is more often delayed than delivered. In fact, sir, as we speak to you, a large-scale transformation of our judicial system is almost upon us. But while we can deal with the large things like the appointments of judges and so on, there are some small things, sir, that will help in meaningful ways to impact on our ability to deliver justice. Mr. Speaker, let me remind this chamber of an event that happened around the time of the last election. You might well remember, sir, because some of the people who elected you might have been impacted, that some Barbadians or some individuals resident in Barbados with residency status in Barbados sought to be included among those individuals who could cast a ballot on election day. And on the eve of the election, not literally but certainly figuratively, these people who had won their case in the High Court still found themselves with a huge barricade between them and the ability to vote. And they appealed to the Court of Appeal, sir. And mere days before the election, they appealed to the Caribbean Court of Justice. Now, sir, we always say justice delayed is justice denied. And we often take what happens in our courts for granted. But what happened in the CCJ in relation to that case Ventos against the Electoral and Boundaries Commission and against the Attorney General demonstrated how a legal system should work, sir. The documents in that appeal were filed in the CCJ electronically. Now, sir, this is not the first time, because for the longest time, documents have been filed in the CCJ electronically. So it's not that that in itself was new. But it is how it was dealt with, sir. Documents were filed in the CCJ. Judges of the CCJ were notified by text message, which came up automatically on their phones, that documents had just been filed in an appeal and that they were emailed to them, and that they needed, more importantly, to give them immediate attention because the court had to hear the matter and rule swiftly, the election in Barbados being only days away. That court, sir, heard the cases. Not a fellow needed to get on a plane and go to Trinidad. Everything was done by video conference, video link, Zoom meeting, whatever you want to call it. And that CCJ was able to dispatch justice as it was needed through the use of technology, sir. But for the longest time, we in Barbados have been flirting with this notion about using technology to change our processes. But we have been performing abysmally, sir, at it. Every government department will tell you, you can do this online, you could do that online, you could do the next thing online, sir. But when it comes to the average Barbadian being able to access services online, it really is a joke. And the court system, sir, is no different. But things that you would give, as they say these days, a blighter, things that you will look at and say, we get that next week, sir. You cannot do those things when you are dealing with the delivery of justice. You can't. And this administration, sir, recognizing that we needed to take serious measures to completely transform how justice is dealt with, we took a decision, Mr. Speaker, that in the shortest possible order, we would move towards something that we call e-filing. Now, sir, sometimes it is the nail in the horseshoe that determines whether the battle is won or lost. But the nail by itself is a fairly insignificant thing. But the part that it plays in the larger system, sir, demonstrates the importance of it. What is e-filing? E-filing, sir, is the use of technology to file documents in court electronically without having to go and appear at the registry to do so. Now, you know, some people say if it ain't broke, don't fix it, sir, but the system is broken. And no matter how many judges we appoint, sir, unless we change the fundamentals, the system will remain broken. So by e-filing, Mr. Speaker, we are putting in place an arrangement in law where individuals' cases, instead of them having to go to the registry and swear affidavits and then come back to the lawyer's office and then the documents got to get sent back across by a court clerk to be filed and you pay $20 or $30 or $40 to a cashier, sir, we're moving all of those things out of the system. They're anachronistic, they're archaic, and we can do a lot better. So with this new system, when you have a case to file, sir, you go to your lawyer, takes your information, and without having to set foot in our High Court registry, Mr. Speaker, he will prepare the documents, you will sign them, he will hit a button on his computer, and off the documents go to the registry. Nobody has to get in a car to go there, nobody has to walk across there in the hot sun. Nobody has to stand up before a legal assistant and taken off, all of that, sir, will be a thing of the past. What are we replacing it with? Mr. Speaker, here's the fundamental change. When a person has to go to the registry to swear an affidavit, which is going to be used in a court case, they have to go to the registry and stand before, well, they sit and they wait until the legal assistant becomes available. And then they go to the legal assistant who takes the document. He or she doesn't read it, they just take it. They don't need to read it, because the only purpose for your being there is to sign it. But that process involves taking a Bible in your hand and taking the oath, and the legal assistant asks, are the contents of this document true? And you say, so help me God, and then you sign, and that's it. That affidavit is now complete. No complete, sir. But it has to be filed physically. Sir, at the registry we have problems with mold. From time to time, documents are mislaid. Sometimes they're even downright misplaced. And all of these are the perils of a paper-based system. I was involved in a case, sir, not long before the last election, and the number of boxes that the evidence was in, sir, if you put them one box on top of the other, it would be about twice your height. Twice your height, sir. Physical paper documents. Now, we are either going to get with it or not. And so the amendment that we're doing today is an amendment simply to allow for a person to take or give an oath before the attorney at law. Small thing, sir. Very small thing. But the moment you do that, it eliminates the need for the individual, together with a legal clerk, to go to the registry to stand up and wait for a legal assistant to become available to do that which they could have done in the lawyer's office. Because all that you're doing is saying, I swear that what I have put in this document is true. That's all you're doing. But it is a necessary prerequisite to filing. There's an argument that really we don't need to do that at all. We just let the body sign and file it, and in many cases, that is what happens when we do what are called witness statements today. But in the special case of affidavits, there is the additional solemnity and importance of that oath that you take. Now, sir, this is just one small, I described it as being perhaps the nail in the horseshoe, which determines the eventual outcome of the battle. In order for us to be able to move towards electronic filing of documents, we are going to have to change a whole set of rules. We're going to have to change rules which will allow the registry to accept documents electronically. We're going to have to change rules which will allow you to serve documents on other parties electronically. We're going to have to change rules which will allow you to pay the filing fees electronically. But these are things that are done practically every place else in the world, and Barbados is coming to this dinner table years and years too late. Well, not too late, but certainly years and years later than we ought to have. Now, we believe firmly that the implementation of these new measures will contribute significantly to a savings in terms of time, in terms of deployment of resources, and also overall in terms of a reduction of costs to litigation. But of course, sir, judges try cases. So there's no point having a filing regime where the case from day one, documents are submitted electronically, without having a situation where the judges themselves now, instead of having to deal with mountains and mountains of paperwork, mountains and mountains of evidence, the judges need to be in a position so that they can deal with the affidavits and the evidence and so on electronically as well, sir. Some people are afraid of technology, but we have seen numerous instances, especially in relation to the delivery of justice in a swift and meaningful fashion, where technology makes the world of difference. Now, sir, I will say to you that it has taken us just over a year to get to this place. But it is a case, sir, where timing is everything. The court year is going to start on the 9th of September. We expect that the software provider that we have engaged to deliver this solution for us, and which software provider, sir, is a not-for-profit company. You cannot find a lot of not-for-profit companies these days developing software. But it is a Caribbean not-for-profit company, sir, which was established to provide the very same system that we are looking to implement in Barbados to the Caribbean Court of Justice. So we're not out there, sir, on a frolic of our own trying to experiment and so on. In fact, this developer, having developed the entire system for the Caribbean Court of Justice, and you recall that they spoke about the election case and how it was handled, this is exactly the same provider that is doing this project for Barbados. At what cost, sir? In the estimates for the year 2017 to 2018, the last administration included in the estimates the sum of $4 million to purchase an e-filing software system for the Supreme Court of Barbados. $4 million to buy it. And the annual license fees, had they bought it, would have been more than $1 million per year. $4 million to buy it, and then annual license fees more than $1 million per year, sir. This entire solution is costing us just about $1 million Barbados dollars. The solution that the last administration was looking at was a solution by a well-regarded Singapore company that does these systems all over the world. But how many times, Mr. Speaker, have you heard Barbadians or Caribbean people lament, why with all that we know, all of our intellect, can we not develop these things indigenously? Why do we have to go as far as Singapore? But yet still we are churning out software developers at every tertiary institution in the Caribbean. Well, we're not doing so in this instance, because the developers of this program are regional developers. They are homegrown, they are tried and proven, supported by the CARICOM institution called the CCJ, sir, and it is coming at a fraction of the cost that the last administration was prepared to commit us to. Now, sir, I call that a win-win situation for everybody. What will it yield for us? As I said, it will reduce costs. It will allow for a more efficient system of delivering justice. Now, this is just one part of where we're going, sir. I believe that I can say to this chamber that earlier this year, we passed an amendment to the Supreme Court of Judicature Act, and that amendment saw us agreeing to establish additional courts in the Supreme Court of Judicature of Barbados. Essentially, Mr. Speaker, we agreed to increase the number of High Court judges from 8 to 13. But in addition to agreeing that we should increase the number of High Court judges, it was also evident that we needed to make appointments to the Court of Appeal, because 3 of our Court of Appeal judges, Mr. Speaker, had left office for one reason or another. instead of following what had been done since the 1970s, sir, in fact, since 1976, we decided, Mr. Speaker, to follow something that has been embraced by the Commonwealth called the Latimer House Principles, which at the core of it says the appointment of judges must be open to all and free of political interference. Now, Mr. Speaker, I well recollect the speech of the Leader of the Opposition when we passed that bill. He did not attribute, in fact, I think he was careful not to attribute any improper inclinations to this new administration, having been a part of it himself, albeit briefly. But he was careful to point out that there was a risk that even though we might put a system in place for open judicial selection, that there might still be political interference, sir. I remind this chamber that that judicial selection committee was chaired by Sir David Simmons, a Caribbean jurist and an international jurist of some renown and distinction. Also on that panel was His Honor the Chief Justice of Barbados, retired Court of Appeal judge in the Bahamas, Mr. Justice Christopher Blackman, Sir Dennis Byron, representatives of the bar and civil society. And that committee posted advertisements in Barbados for the judicial appointments for the posts that were vacant within CARICOM and across the Commonwealth, sir. And we received applications from countries near and far. That Judicial Selection Committee over the last 8 weeks, having received the applications, interviewed, shortlisted, and made a final recommendation to the Prime Minister. And the Prime Minister, having accepted every single recommendation of that committee, has commenced the process of consultation with the Leader of the Opposition. I expect, sir, that that process will be completed with some dispatch, I hope. But when that process is done, we will see additional High Court judges being made available to the judicial system of Barbados to try cases and to get them moving through the system. It can give a modern country, sir, no pleasure to know that the World Bank, in looking at the ease of doing business in Barbados, look at the judicial system and the resolution of commercial disputes in our courts. And we were rated, sir, among the lowest in the region. And their assessment is that where other countries are able to dispose of commercial cases in 1 year and 2 years, Barbados is disposing of them in 5 years and 6 years, sir. And I'm sure you know of some where there are cases that have not yet been resolved, and we are now into year 8. There is a particular High Court judge, sir, who has retired and gone back to private practice, but still has outstanding judicial decisions to give, which he cannot now give. And who, sir, is going to, and he retired over 10 years ago now. And those litigants now are so frustrated and burnt out by the system that they're not even interested in starting over. Because under the law, sir, when once the case is finished and the judge is no longer a judge, the only thing you can do is to start over a case. Who wants to start over a case that they did 20 years ago, 25 years ago? These things are to our constant shame and embarrassment. In a recent decision in Trinidad of the Court of Appeal in Jamaica, the Court of Appeal in Jamaica reminded the litigants that our own CCJ has said that it is almost impossible for even the most complex of cases to take longer than 6 months delay in giving a decision. I can read the passage. I know that my friend, the leader of the opposition, has his people who advise him on these matters. But the case, sir, I can give you the name of the case too. The case talks about the length of time. And that case essentially reaffirmed the recommendations of the court in Trinidad, the CCJ, and said that there's no reason why more than 6 months should pass before a judge delivers a decision. No reason why, sir. But yet still in Barbados, we have judges who have decisions on interlocutory matters now going on 5 years, sir, and it has to be said in this place that what they're doing is infringing the constitutional right of litigants to a fair hearing. That's what they're doing, sir. But the chamber will remember that we've amended the Constitution to provide that if a decision is not given within 6 months, that it can constitute grounds for removal from the bench. The point I'm really trying to make subtly, sir, or perhaps not so subtly, is that what is required to turn around the systemic delays in the delivery of justice in Barbados is not a single magic bullet. We have to tackle all of the issues. It is a fact that Barbadians have become much more litigious in recent years than they used to be. And so we are having in the region of 2,000 and almost 3,000 cases being filed each year. But there's no system of justice, sir, which can see 2,000 and 3,000 cases moving in and out of a system within a short space of time, because in year 2 you now have 4,000, in year 3 you have 6,000, in year 4 you have 8,000, and after 10 years you got 20,000, sir. But you still only have a small number of high court judges. You are still relying on old systems where technology is not fully involved. So before we can say that we have tackled the issue, we have to pull all the parts together, see what has been going wrong, and make changes. One of the areas in which we have been going wrong, sir, is by believing that 2 High Court judges exercising the criminal jurisdiction of the High Court of Barbados can dispatch the number of criminal cases that come before it. There is no universe, none, sir, in which 2 High Court judges can deal with a backlog of almost 70 murder cases and over 1,100 indictable matters. There is no way, sir. Simple mathematics will tell you that each judge will have to do 550 cases. Now, how can each judge do 550 cases in short order? And remember that more cases are added every day. So you will always be behind. You will never be able to catch up, never be able to become, to get a position where you break even. Recognizing that, sir, among these 13 judges, out of these 13 judges that our High Court will now be constituted of, we are going to ensure that a number of them are dedicated to the criminal jurisdiction. But the Prime Minister has also settled and has invited the Leader of the Opposition to give his fiat to the appointment of 2 individuals to serve as temporary criminal judges. Then this system, as long as we get the fiat of the Leader of the Opposition, sir, we'll be able to have 5 criminal courts functioning in Barbados simultaneously, sir. 5. Now, I will remember that in the last administration, I guess withering under the attacks of a then vibrant opposition, not that this opposition is not vibrant, sir, but it's only when you're in opposition of one, it is difficult to be as vibrant as you would like to be. And I would like to urge the opposition, it is not too late to come back over to Damascus. I, for one, would welcome him and his intellect with open arms. Come back over to Damascus, sir. But even if you feel that you can't, give us your support when it comes. But, sir, with 5 criminal judges, we will finally begin to make a dent in those criminal matters. And perhaps, Mr. Speaker, you recognize that I'm veering a little bit off of the evidence point. But I think, sir, that it has been some time since this chamber has heard me speak on matters relating to the delivery of justice, and I crave your indulgence and I crave the chamber's indulgence, because I think that we've done enough that it's time that the chamber benefit from a report, though in time to come, sir, a more fulsome report will be tabled to the chamber. So 5 judges will deal with criminal matters and help to bring a dent in those, sir. And that fact, and we've told the DPP, we can't give the DPP instructions under the Constitution, but we've indicated to the DPP that we want her office to concentrate on what else, sir? On the homicides, on the murders. Because there's a prevailing view among the criminal element in Barbados that they can do as they please, and that the day of reckoning does not draw nigh anytime soon. But they are up for a very, very rude awakening, sir. Because with the start of this court year, the criminal bench of Barbados will be focused almost exclusively on dispensing justice to those persons accused of murder. And I believe, sir, that when once the criminal element recognizes that the system is finally catching up with them, sir, that some of them will think twice about the reckless lifestyle that they've been engaging in over the last few years. I think, sir, it doesn't take a rocket scientist to figure out that if people believe that there is no accountability, that they will simply feel that it is open season and that they can do as they please. Well, the people of Barbados are entitled to visit those accused with accountability, sir. And that I consider to be my job number 1. Now, in addition to that, though, sir, the criminal bench is only one part of it. It is still a large number of cases that we have to get rid of. And as I've told this chamber before, we're looking at putting other systems in place where some of those cases that are not of, they're in the assizes, they're to be heard indictably, but some of them, it's probably unsafe to try them now, having been in the system for so many years, witnesses having died. All those things are going to be looked at to see how we can move some of them off of the agenda. But in addition to the increase in the number of judges, sir, we will also see, and I've told the chamber before, that 3 commercial court judges will now be sitting exclusively on commercial court matters. 2 family law judges will be sitting exclusively on family law matters, sir. And then we will have the other judges who will deal with all of the rest. Now, I wish that we could do more, because I don't think that this number of judges is really optimum for us. But the fact is that we do have constraints. It would be good, sir, if we could do what Bermuda did or what Trinidad did. I think Trinidad doubled the size of their judiciary. In a recent discussions with the Bahamas Attorney General, he told me that they have about 12 high court judges doing nothing but criminal matters. 12. But, sir, we have to manage our physical requirements and our financial requirements, sir. And I think that these appointments of additional high court judges, so long as we get the fiat of the leader of the opposition, will go to make a big difference in how justice is dispensed. But I also must say, sir, that the lawyers have to be willing to come to the table. Judges have a duty to sit. That's the language we use. That's the language of jurisprudence, that they are under a duty to sit. But
and give decisions, honorable member, and render decisions.
Well, that is all part of that is all part of that duty to sit, sir. You must, by sitting, we mean that you must hear the case, you must try the case, and you must deliver decisions. But it also means, sir, that if we're going to put that, if judges are going to discharge that solemn responsibility in the way in which the society desperately needs, it also means, Mr. Speaker, that the bar is going to have to come along. And by introducing these technological changes, they're intended in great measure to benefit the bar and to benefit the litigants. Just imagine, sir, one of those days when you have to send your clerk over to the court 6 and 7 times a day to deal with various witnesses, all of whom have to swear affidavits, and can't get nothing else done. They don't have time to go to the company's registry, don't have time to do this, don't have time to go to the land registry. Just imagine what a difference it will make to your ability, sir, to practice law, to carry out your duties to your clients, and not unimportant, sir, to earn fees. Then we implement a system where judicial matters are driven technologically. But we flirted with it for too long. Under our current laws, Mr. Speaker, you can do hearings and take evidence without the person being present. But how often are we doing it? We're not doing it often enough. When the new Supreme Court rules were passed, the civil procedure rules, we had this idea that you would sit in your office, one lawyer on one phone, and you in your office on another phone, and the master of the court, sometimes even the judge, would be in his or her chambers and hear the matter. And, you know, you wouldn't do a trial that way, but you would do some interlocutory matters, and you wouldn't have to leave your office. But you know what, sir? Somehow or another, we haven't seized the opportunity. And so we have remained mired in the past, constantly doing the things that we came and found the older generation doing, without recognizing that there's a solemn responsibility on a new generation to completely transform how we relate to the courts, how we relate to each other, and how we deliver justice. Mr. Speaker, the next few months are going to be a challenge. We're going to be appointing new judges. We've made significant changes to our court system, but some things that we had planned to do, we now have to do differently. We're going to make a few more physical changes to the High Court, but we have enough courts to be able to allow the court system to work. One of the matters that I think it is important to talk about is how we use our facilities. And this is not just our courts, this is perhaps every other government building that we spend millions and millions of dollars on. We believe, sir, that the time has come when our courts need to start doing what courts do overseas all the time: meet in the evenings. You have courtrooms in our Supreme Court building that we spent $100 million on that are empty by 1 o'clock. Empty by 1 o'clock, sir, in the day. And will not see another human being feel another human breath until the next day at 9:30 or 9 o'clock when the legal assistant walks in, sir. Now, let's think about that. If court starts at 9:30 and the courtroom is empty by 1, but let's say 1:30, that is 4 hours, sir. That's 4 hours.
Honourable member, with great respect, even though I don't like to interject, you mean 9:30 at optimum, but you mean 10:30 and 11 as the norm, honourable member?
Sir, it's been a year and a few months since I was last there, but I think that what you are describing might still be happening, sir. So a courtroom in a building on White Park Road could well be used for 4 hours a day. Now, I have to be fair. I have been in that court. I've been in those courtrooms, and we've taken up sometimes 8, 9, 10, 11 hours, and we've worked late into the night. But on average, sir, on average, the courts are empty by mid-afternoon, and will not see another human being until the following morning. Now, how, sir, is that a good use of Barbados's resources? How is it? It can't be, sir. You know, when I went to Trinidad to law school in 1989, I got the shock of my life. I discovered that secondary school students were going to school in shift. I still can't believe it. They were going to school in shift. So you had school students who were going to school at 7 o'clock in the morning, and they would go to school from 7 until 12:30, and at 1 o'clock, sir, school start over. In the same building, in the same laboratories, in the same toilets, on the same pasture, but with a fresh crop of another 1,000 students. And they will then go to school from 1 o'clock until 6 in the evening. Now, it is true that Trinidad had peculiar pressures, but isn't that a sensible way, sir, of using physical resources? But nothing can happen to the school bench by having another butt sitting in it for another 6 hours. A facility, Trinidad, now has had then and still have schools operating on a shift system. Now we scorn that because somehow or another, you know, no, that can't be right. But it's about maximizing use of your resources. Now, in all fairness to the Minister of Education, ma'am, I am not commending that. I am only saying that we have experiences not too far away from us where instead of leaving our facilities empty, they have actually adjusted the working day so that they can get twice the use out of a government installation rather than having to go and look for money to go and build another government installation. I'm not asking that our school children go to school in shift, but I am saying, sir, I am saying that in a modern judicial system, there can be no reason why when one court finishes at 1 or 2 o'clock, a new judge, cannot now convene a fresh case in the same place. Because if we don't adopt that approach, we're going to have to find ourselves building and building and building and building more. There's no mystery to it. You rent a room at Sherburne Conference Center or at the Hilton Hotel from 9 until 12. And at 12:01, the people are there welcoming you, thanking you for coming and so on, and ushering you out, setting back up the room because they have another engagement in the same room at 1:30. Now, if you could do that in all those kind of facilities, sir, surely you can do it in a court. And one of the features that will attend this administration's new approach to delivery of justice will not only be about putting additional resources there, but also making sure that we get as much out of the existing resources as we can, and that will, I say to the public, it will see courts sitting in Barbados in the evenings. Now, there are some matters that you would not do that. We would not, let me say that matters in the criminal jurisdiction are not appropriate for that. We may not even want to do family matters in that way. But a large number of civil matters, sir, can see lawyers like yourself, other senior lawyers in the private bar, being able, even lawyers in the government service, sir, being able to devote the early half of the day to one set of activity, it might even be preparation, sir, and then starting the case at 2 o'clock. We have to do things differently if we are going to make the change that we need to see in Barbados. Now, in addition to the appointment of judges and the changing of the system, other initiatives are going to have to be rolled out. One of the areas, sir, in which we want to see an increased use in technology will be the how people get police certificates of character, for example. I know I'm straying, but I think it's a central theme that has to be seen as being connected. If we keep seeing all these technological innovations as being something else but not for me, then we will never have a holistic approach. I've taken a briefing. We've invested money in digitizing all of the criminal records of convicted persons in Barbados. All. Because as you know, sir, the current system, when somebody asks, is he known? Somebody got to go and go search through a filing system, look for your name, John Brown, or whoever it is, and then they run back with a card and it written in handwriting that it could barely read, and say, yes, sir, he's known. I can't quite make out what it is that he get charged with, but he get 2 years for that. That's how it is done now. But we are moving Barbados into a modern era, so all of those cards, all that data is being digitized. Well, what does that mean? It means, sir, that when you apply for police certificate of character, nobody has to go and search for a long form no more. Nobody got to go and search that record. It is all there. And currently what happens, Mr. Speaker, is that you apply for police certificate of character and they tell you you can get an appointment in about 8 weeks. And so you then go back for the appointment, and then you got to wait another couple of weeks before you can actually get the certificate of character. And by that time, the job that you want the certificate of character for, gone to somebody else. We are intent, sir, on bringing the period of time between application for certificate of character and the delivery of that certificate of character to anywhere between 3 to 5 days. But how are we going to do it, sir? Well, again, it's going to be done digitally. And we've asked the Ministry of Industry, Science and Technology to work with us on developing an app, and it is almost finished, sir, so that an individual, Mr. Speaker, who wants to apply for a certificate of character will pick up his or her phone or his or her computer or tablet or whatever it is. We know everybody doesn't have those, but we get them in a minute. And he will complete the application form online. And he will make the payment through something called Easy Pay, a new government portal to accept money without you having to go and stand up at the Treasury or at the post office or something like that. Okay, he'll be given a number, and he will show up and collect his police certificate of character in about 2 or 3 days. That is where the technology has taken us. And we can no longer be content, sir, to wallow in the past where you go and stand up in a line and use up all of your productive time. All of your productive time, sir, in order to be able to get a certificate of character. Well, you can't apply for it when you get home in the evening. Very shortly, you will be able to, because that's where the technology has taken us. Mr. Speaker, as I said, this is perhaps a small amendment. It is an amendment to the Evidence Act, which will allow attorneys at law to take affidavits from their clients. It is an amendment to the Interpretation Act for the same purpose. Let me make it clear, this does not eliminate all the other methods. But we believe, sir, that very shortly what will happen is that nobody will be going to registry at all for that purpose. They will just take the oath before their lawyer. We also have another somewhat anachronistic thing in relation to notaries public, where notaries public and commissioners of oath they exist in Barbados by virtue of the office that people hold. I remember being in Las Vegas not long ago, about 3 or so years ago, sir, and I had to sign a document before a notary public, and he mailed it back to Barbados. And when I Googled the nearest notary public, sir, the nearest notary public was in an Office Depot. So I showed up at the Office Depot. Could I see notary public, please? I thought it was going to be shown into a room with a man in a suit or a woman in a suit in an office and a sign marked notary public. The gentleman who was selling printers was the man who came over to me and said, "So you're looking for a notary public? Give me 1 minute." The man who was selling printers, sir, and he went and he get his notary public book, and he do the document and he stamp it, and I paid him the $20 and I was on my way. He was the guy dispatching, as we would say, in Office Depot. And all across the world, sir, people are making the conduct of business easier. While 4 years ago in Barbados, we decided in this chamber that we were going to completely change the system of notary public in Barbados by increasing it by 3. Sir, I want to say to this chamber, I want to say to the people who rely on those kinds of services, that over the course of the next 12 months, you will see us completely transforming how those services are delivered by opening them up to just about anybody of good name, sir. In the United States, any document to be signed before a notary public can be signed before a lawyer. That's what I'm told. But in order for you to sign a document before a notary public, you got to go up to the registry and sit down and wait for 4 hours, and you got to bring a 10-cent stamp and $25. A lot of stuff, sir, that our country can do without. And I am intent, sir, I am intent on moving our judicial system into the modern era. With the support, sir, of this chamber, it is a small measure, but I believe that it will significantly reduce time, it will reduce costs, and it is the one thing, it isn't the only instrument. We have to change rules, sir, but the rules don't come to Parliament. We have to change about 7 other pieces of rules, because non-contentious probate rules, you'll be filing documents electronically. Bankruptcy rules, filing documents electronically. Any matter that involves you going before a judge, you'll be able to file and serve and deal with electronically. It gets bumped to the judge's computer. He or she will open up the computer and the documents are there, sir. They don't got to walk home with 5 and 6 boxes in the trunk of the vehicle so that they can write a decision. Everything is online. Mr. Speaker, a small initiative, but I think it's the beginning of a journey that will take us a long way in bringing about change in how we see justice and how we deliver justice, and in helping us to reduce the cost. And with those words, sir, I'm obliged to you. I beg to move, sir, that this bill be read a second time.
The question is that this bill be read a second time. All those honourable members in favour, please say aye. Those against, please say no. We think the ayes have it.
That you do not leave the chair and that this House resolve itself into committee.
The question is that the Speaker do not leave the chair and the House resolve itself into committee for further consideration of this bill. All those honourable members in favour, please say aye. Those against, please say no. We think the ayes have it.
Right, Sandy. I was.
This House is now in committee.
Clause 1.
Beg to move that Clause 1 stand part.
Second.
Question is that Clause 1 stand part. All honourable members in favour, please say aye. All honourable members against, please say nay. Methinks the ayes have it.
Clause 2.
Beg to move, ma'am, that Clause 2 stand part.
Question is that Clause 2 stand part. All honourable members in favour, please say aye. All honourable members against, please say nay. Methinks the ayes have it.
Schedule.
Beg to move that the schedule be the schedule to the bill.
Question is that the schedule be the schedule to the bill. All honourable members in favour, please say aye. All honourable members against, please say nay. Methinks the ayes have it.
Report.
Beg to move that you do now report His Honour the Speaker the passing of one bill in committee.
Seconder?
Second.
Question is that I do now report to the Honourable Speaker the passing of one bill in committee. All honourable members in favour, please say aye. All honourable members against, please say nay. Methinks the ayes have it.
The chairman of committees has reported the passing of one bill in committee.
Beg to move that this bill be read a third time.
question is that this bill be ready a third time.
Let me see it, sir.
All those honorable members in favor, please say aye. Those against, please say no. Me think the ayes have it.
Mr. Speaker, I beg to move that this bill do now pass and be cited as the Evidence Miscellaneous Provisions Act 2019.
The question is that this bill be now passed and so cited. All those honorable members in favor, please say aye. Those against, please say no. Me think the ayes have it. This bill is so passed and so cited.
Somebody? Watch the tape again. Order number 9, sir. In the name of the Honourable Minister in the Ministry of Economic Affairs and Investment, to move the passing of a resolution to approve the borrowing by the government from Republic Bank Barbados Limited of the sum of up to Barbados $26.3 million to repay existing overdraft facilities held by the Barbados Transport Board, the National Housing Corporation, and the Queen Elizabeth Hospital.
Honorable member for Microsoft Central.
Thank
Yeah.
you, Mr.
You know, when you mentioned that thing with
Sir, this
the,
is
no.
not a small amount, but a reasonably administrative matter. This resolution to approve the borrowing of up to Barbados $26.3 million in a term loan from the Republic Bank of Barbados. And I will read the resolution before going into an explanation of why we find it necessary to ask this House to approve. Whereas by Section 2 of the Special Loans Act, Cap 105, the government is authorized from time to time to borrow from any bank, corporation, company, or other institution sums of money not exceeding in the aggregate Barbados $2.5 billion on such terms as may be agreed upon between the government and the lender of any such sum of money. And whereas by Section 3 of the said Act, it is provided that any money borrowed under the authority of the Act shall be appropriated and applied to such purposes as Parliament may approve by resolution, and that such money and any interest payable thereon is charged under the general revenues and assets of Barbados. And whereas the government considers it necessary to borrow the sum of up to Barbados $26.3 million from Republic Bank Barbados Limited to repay existing overdraft facilities held by the Barbados Transport Board, the National Housing Corporation, and the Queen Elizabeth Hospital. And whereas the said sum of up to Barbados $26.3 million is borrowed on the terms and conditions contained in an agreement, the main provisions of which are set out in the schedule, and whereas the said sum of up to Barbados $26.3 million is within the authorized borrowing limit given to the government under Section 2 of the said Act, be it resolved, therefore, that Parliament approve the borrowing of the said sum of up to Barbados $26.3 million from Republic Bank Barbados Limited to repay existing overdraft facilities held by the Barbados Transport Board, the National Housing Corporation, and the Queen Elizabeth Hospital on the terms and conditions contained in the agreement, the main provisions of which are set out in the schedule. Sir, let me explain briefly why we are asking that this resolution be passed. Now, in October of last year, the government of Barbados successfully completed our domestic debt exchange, and as part of this exchange, the government assumed approximately Barbados $718.1 million in loans held by a number of state-owned enterprises. And these loans were exchanged for new government of Barbados securities. Now, in line with the terms that we negotiated with the domestic creditors, overdraft facilities held by SOEs were excluded from the domestic debt exchange. But what we found was that there were a number of SOEs that had substantial overdraft facilities that would prove challenging to service under the current conditions. These SOEs were the Transport Board with an overdraft facility of 10 million Barbados dollars, the National Housing Corporation with an overdraft facility of 10 million Barbados dollars, and the Queen Elizabeth Hospital, whose facility was 6.3 million. These overdrafts are held at Republic Bank Barbados Limited and the Bank of Nova Scotia in the case of the Caribbean Broadcasting Corporation, which is not covered under this resolution, but whose overdraft was 2.5 million. So in order to assist these SOEs with their own financial viability, we are asking that these overdraft facilities now be closed and that they be converted to term loans, which will be serviced by the government. So we've held negotiations with the creditors and reached an agreement on the financial terms, so that the main indicative terms and conditions of the facility are that we borrow from the Republic Bank up to 26.3 million Barbados dollars, that it be repaid over a term of 18 months, that the repayment be monthly blended payments of both the principal and the interest, totaling approximately 1.5 million, $1,519,629, and that the interest rate be 5% fixed. Now, the loan is to be facilitated under the Special Loans Act, Cap 105. As at May 31st of this year, 2019, the outstanding balance of loans raised under this act stood at approximately $693.3 million. It means then that this additional loan of up to Barbados 26.3 million is within, as read in the resolution earlier, the $2.5 billion limit that is prescribed by law. So assuming, sir, that the central government arrears are held constant at 293 million Barbados dollars, it means that taking on this new debt of 26.3 million will result in an increase of government's debt by about 0.3% of GDP. Now, it does mean at this point an increase in the debt stock. However, it means that the debt stock would not go over the agreed threshold under the IMF Extended Fund Facility. So the target under that threshold is Barbados 12.6 million. And it means that the addition of this debt would not take us over that agreed target. I go further, sir, to say that the debt stock will be reduced by approximately 89 million by the end of September 2019 due to scheduled debt repayments. So let me explain in a little bit more detail. It means that while, as of today, once this resolution is passed and the agreement is signed, the loan of 26.3 million will temporarily increase the debt stock, but once scheduled debt payments are made by the end of September 2019, the debt stock will be reduced by 89 million Barbados dollars. So all that remains for me to do is to make a brief comparison, if I can, between the interest and the terms that existed under the previous overdraft facility and what exists now. And it is really to give assurance that this is really more of a swapping out of debt and not an addition of debt. It is only with reference to debt that could not be addressed under the domestic debt exchange based on the terms that we agreed with the creditors. And so I would want to add that the interest rates on the overdraft facilities prior to the agreement that they be converted to this term loan would have been as follows. The interest rate on the Transport Board and the Queen Elizabeth Hospital overdraft facilities was 8.7% per year, and the interest rate on the National Housing Corporation overdraft facility was 9.95%. The interest rate on the currently proposed loan with Republic Bank of 26.3 million is 5%. So it is in fact a swap that amounts to better terms for the government of Barbados. And so, with those few words, sir, I am asking that this resolution to borrow up to 26.3 million Barbados dollars from the Republic Bank of Barbados be passed. I'm obliged to you. I now move that the resolution be passed.
The question is that this resolution be now passed. All those honourable members in favor, please say aye. Those against, please say no. We think the ayes have it. This resolution is now passed.
Order number 10, sir. In the name of the Honourable Leader of the House, to move that the House resolve itself into Standing Finance Committee to consider the grant of sums of money for the service of this island. Oh, yeah, is that one?
It's 10. 10.
We had order.
It's 10. It's 10. It's 10.
One about 11.
I see. Is this the one that speaks at 2.07? Is this one that speaks to the 2.7 or the one that speaks to the 4? You want to speak to the 4 million?
Mr. Speaker.
Honourable Leader of Government Business.
Thank you, Mr. Speaker. I beg to move that you do not leave the chair and that the House resolve itself into committee. Standing Finance Committee. Thank you.
The question is that the Speaker do not leave the chair and the House resolve into Standing Finance Committee for further consideration of this resolution. All the honourable members in favour, please say aye. Those against, please say no. Me think the ayes have it.
This House is now in Standing Finance Committee.
Chair, in the name of the Honourable Leader of the House, to move the passing of a resolution to grant the sum of $4,833,540 from the Consolidated Fund and to place it at the disposal of the government to supplement the estimates 2019 to 2020 as shown in the supplementary estimates number 3, 2019 to 2020, which form the schedule to the resolution. Head 22, Ministry of Information, Broadcasting and Public Affairs, in the amount of $1,016,633.
Honourable Member St. Michael South East.
Thank you, Madam Chair. I rise to introduce the request for the supplementary provision for Head 22, Ministry of Information, Broadcasting and Public Affairs. The consent of this chamber is being requested for a supplementary allocation of funds in the amount of $1,016,633 under this particular head. The request, Madam Chair, is for the purpose of meeting expenses for the operation of the Government Printing Department under Program 44. Government Printing Services Sub-Program 50 of the Printing Department in the category of other charges for the period July 2019 to 2020. The specific allocation of the funds are as follows: for the purpose of travel, $3,000, utilities, $193,000, rental of property, $11,283, supplies and materials, $650,450, maintenance of property, $135,500, and operating expenses, $23,400. Now, the Government Printer Department had initially submitted a total amount of $4.7 million for its estimates of expenditure for the financial year 2019-20, of which $1.2 million represented other charges. The department was initially requested, as you know, in compliance with what all of us have been asked to do to reduce its expenditure, and this was reduced to the sum of $2.7 million. In adjusting the submission to meet this target, the department would have lowered its request under other charges to $988,000. However, the allocation that was finally approved for expenditure under other charges was $199,117. The amount allocated to the government printery to cover the utilities for the financial year 2019-2020 was $36,000, and this represented approximately $193,000 less than the sum originally requested by the Government Printery Department. This department has indicated that it spends approximately Barbados $17,000 per month on electricity, water, and telephone charges, and the sums sought at this time are therefore necessary to cover the outstanding payments, particularly in relation to electricity charges, and to meet its projected needs for the remainder of the financial year. With respect to the supplies and materials, the government printer has calculated a need for $650,450. It is drawn to the attention that the printery has almost completely exhausted its current stock of paper and chemical supplies, and therefore this request is perhaps somewhat urgent, and while we are in the process of revamping and restructuring the printery to ensure that not just that department but that all departments move in a technological direction and to be further digitized, obviously, that process still takes time, and in the interim, there are obviously going to be some requirements that the department will have. There's a need for paper for documentation for both customs, the licensing authority, the police department, the Queen Elizabeth Hospital, and other government departments, as well as non-government clients that may specifically request the print services. Obviously, this department was originally contemplated to be part of the restructuring process for digitization. It was contemplated we would have had it completed early in the year, and the intention was obviously to restructure the department, modernize the operations of the online publishing services and intranet, and to include a number of new information technological systems and operational upgrades. The overall rationalization project, however, was postponed, but the budget cuts remained in place. And this largely explains the shortfall in funding that the printery now faces. The ministry has no excess or savings that could have been made available of funds, which would have been able to allow it to respond to these situations to avoid us having to come here to request a supplementary. The situation, Madam Chair, is that obviously as we move towards digitization of this, what has perhaps been an entity that has been long in existence, it is clear that if we are to transform the Barbados economy, that digitization of this department, and certainly of all essential services, has now become of critical importance, and therefore this supplementary seeks to basically seek Parliament's approval to be able to grant the specified sums. It is therefore, Madam Chair, not a very complicated request in terms of the supplementary, but I do feel that it speaks to government's intention to transform the government departments and to ensure that we are compliant. But given the situation with respect to the shortfall, the request for the approval is for the sum of the $1,016,633. Yeah. Beg to move? Yeah. I beg to move, Madam Chair, that head 22 do now stand part.
Question is that head 22 in the sum of $1,016,633 now stand par. All honorable members, well, seconded. All honorable members in favor, please say aye. All honorable members against, please say nay. Methinks the ayes have it.
Head 87, Ministry of Education, Technological and Vocational Training, in the amount of $3,816,907.
Honorable member for St. Michael Southeast.
Thank you, Madam Chair. The second supplementary under head 87 is specifically to cover the cost of the Skills for the Future program. It should probably be noted at the outset that the amount of this supplementary will be refunded by the Inter-American Development Bank, and therefore my honourable colleague on the other side need not be concerned too much by that, because it really is a minor matter in terms of us being able to place funds at the disposal of the ministry, but these sums are already assured by the Inter-American Development Bank for the purpose of refunding the government of Barbados. Just to give some background to the program, Madam Chair, back in May of 2012, the government of Barbados would have entered into some negotiations with the Inter-American Development Bank for a loan in the sum of 40 million Barbados dollars. And at the time it was to support the education and training sector. The title of that program was the Skills for the Future program. The intention would be that it would provide $1,013,144 Barbados dollars through the government of Barbados as an in-kind contribution. The loan agreement was subsequently signed in November of 2012, and the overall development objective of the program was to support the government's human resource development strategy at the time, with an emphasis on improving the quality and relevance of secondary education and the effectiveness of the technical and vocational education and training program. The program aimed at expanding opportunities for demand-driven training and skills certification by supporting the implementation of a national qualifications framework that incorporated the National Vocational Qualifications, NVQ, as well as the Caribbean Vocational Qualifications, CVQ, and or international qualifications for occupations for which competency-based training is being demanded by employers and workers in Barbados. There were several components and objectives of the program, specifically to provide support for an employer-driven training system, which essentially meant that we would seek to align the supply of training with market demand, and therefore the loan resources were to be used to manage and operate a pilot competency-based training fund under the oversight of the TVET Council. The second component was to improve the quality and relevance of post-secondary and secondary education. The intention was that we would provide our students with core life skills to enter the labour market or continue their studies. This component involved the training of heads of departments of various secondary and post-secondary institutions in new teaching practices and the execution of what was then referred to as a School Improvement Grant Initiative and the implementation of a program directed at these life skills called AGNAR. A third component was to look at institutional strengthening. This component was a partnership between the Ministry of Education, the Ministry of Labour and Social Partnership Relations at the time, and the Urdeston Training College, and publicly funded technical and vocational training, the TVET Council, and institutions in business plan development and implementation. It would have encompassed leadership and capacity development, as well as an improved data and information system. And finally, component 4 was a communications campaign, which entailed a communication strategy to disseminate the objectives of the project, to promote the development and implementation of the MVQs and the CVQs, and to raise the profile of the TVET in Barbados. Additionally, there was also a focus on ensuring that there was gender equality promoted at the TVET level, to ensure that more women were able to enter what would traditionally be considered a male-dominated field, particularly in the traditional trade areas as well. A number of challenges, however, Madam Chair, were experienced during the execution of the program. During the 2019-2020 financial year, a number of the challenges were delays in the execution of the activities. There was a termination of a procurement of civil work activities at Samuel Jackman Press Institute of Technology, and there was a shortfall in funds approved for the financial year 2019-20. As a consequence, that would have impacted on the ability of the program to be completed within a specific time. It is now anticipated that the post-secondary institutions improvement grant would have commenced, it had been anticipated that the post-secondary improvement grant would have commenced in 2018-2019 financial year, with the call for proposals having been issued with a submission deadline of May of 2018, which was then revised to August of 2018. And the final proposals from the Barbados Vocational Training Board, SJPI, and BCC were received in late December 2018, and then subsequently approved by the IDB in February of this year. The proposal for Urdeston Training College was also approved in May of this year, and it was therefore not possible to expend the funds as anticipated in the 2018-2019 financial year. The delay in the civil works at the Barbados Community College was as a result of some late payments to the contractors in the initial stages, as well as some construction delays, which were not directly associated to the late payments, but nonetheless, that is back on track. In relation to the civil works at the SJPI, the ministry would have commenced the procurement process in order to execute physical upgrades on specific areas of the institution, in an effort to meet the accreditation standards, with 2 firms being requested to respond to the invitation bids. One of the challenges was that the quoted cost for the project was higher than the budget allocated. This challenge was compounded by the limited time that was available to complete the procurement process and the civil works activities before the disbursement deadline for the loan of November 2nd, 2019. It was therefore determined that it was unrealistic to continue with the procurement process at that stage, but that the funds should be reallocated to other program upgrades at the institution. As a consequence, the reallocated funds were used for the upgrades to the 3D printing mechanisms, the creation of a maker space for robotics, upgrades to the electronics laboratory and the requisite program, and upgrades to the garment technologies laboratory. The IDB granted permission for the reallocation of those funds in February of this year. And let me just say, Madam Chair, that having visited the SJPI plant, I'm quite satisfied with the work that has been taking place there as a result of these loan funds. Several students have benefited, and several persons who have gone on to become not only self-employed but employed as well as a result of the diversion of these funds in this area. In particularly with the 3D printing program, it is quite a state-of-the-art piece of technology that is employed at this facility. I think it lends itself for future partnerships, certainly with persons in the tourism sector, because they have the capacity certainly to create very innovative and certainly very new designs in relation to a lot of our souvenir products as well. So it is certainly an area to watch in relation to what is possible in terms of future output from that institution. Also impressed at that institution was also the area of the garment technologies laboratory. Again, another set of state-of-the-art equipment. I think one of the major challenges for us across the sector has been that the demand sometimes is greater than our spaces. It is certainly greater than the ability of us to train as quickly as we would like some of the tutors and stuff at the institution. But I know that in speaking with the board, we're trying to move towards a position where the facility can be utilized for longer hours as well, to ensure that any concerns in relation to not making the most of the time at the facility during the daytime certainly is addressed as well. So in the future, it is hoped that there will be additional programs on the agenda for the facility to accommodate the number of applications they have been receiving. Also, with respect, Madam Chair, to the training of the heads of departments of the secondary schools, the training for teachers in literacy and numeracy, and the assessment of apprenticeship and internship systems had been delayed initially, but those are since back on track. You would know that I am very keen on ensuring that our teachers receive appropriate support in the classroom, both in and out of the classroom, and so we've made a concerted effort across all areas in education to be able to give them these skills to be able to cope. We've been looking at the statistics both in Maths and English, and we have been seeing some declines. I don't think it is any surprise to anyone what the results have been showing, but we need to get back to the basics certainly in relation to literacy and numeracy, and it is felt that a lot of emphasis obviously has to be provided on equipping our teachers to be able to deliver teaching and instruction for the benefit of the students at the various institutions. Now, the other aspect, Madam Chair, with respect to the funds that were approved versus the funds requested in 2019-2020 estimates, it should be noted that when we would have submitted the draft estimates back in October of last year, the sum of $4,329,581.60 had been requested. However, only $3,970,480 was approved for release, which therefore represented a shortfall of $359,173.06. To fulfill its financial obligations under the Skills for the Future program and to achieve a successful November 2nd, 2019 project closeout, the Ministry would therefore, of Education would therefore require the remainder of the original amount requested in the draft estimates, and that is therefore a component of the appeal today in relation to these estimates. The other area of concern was that when the amount that was originally earmarked for these activities were done under the assets under construction category, we requested that now be directed to program improvement initiatives at the SJPI. However, given that funds for assets under construction obviously cannot be moved to professional services, the supplemental request has been increased to reflect an amount that is inclusive of the funds originally earmarked for the civil works. I therefore, Madam Chair, given all that has been said in relation to the how the monies have been expended, would ask for due consideration of this supplementary to be given. I can assure the House that this particular project has met with the support of not just other ministries, including the Ministry of Finance, but the IDB also boasts of almost perfect performance in relation to Barbados on this project. So while there have been some setbacks in recent times, it is perhaps one of the better performing projects thus far, and it has actually helped to equip not just the private sector, but certainly the schools as well, with the necessary resources that are required to get them going. So, Madam Chair, with those few words, I beg to move that the head 87 do now stand part.
Question is that head 87 in the amount of $3,816,907 stand par. All honourable members in favour, please say aye. All honourable members against, please say nay. Methinks the ayes have it.
Madam Chair, I beg to move that you do now report to the Speaker the passing of one money resolution in committee.
Question is that I do now report to the Honourable Speaker the passing of one money resolution in committee. All honourable members in favour, please say aye. All honourable members against, please say nay. Methinks the ayes have it.
The chairman has reported the passing of one money resolution in the Standing Finance Committee.
Okay. Mr. Speaker, I beg to move that this resolution now be read a first time.
The question is that this resolution be read the first time. All those honourable members in favour, please say aye. Those against, please say no. Methinks the ayes have it.
Mr. Speaker, I beg to move that this resolution now be agreed to. Be read a second time.
The question is that this resolution be read a second time. All those honourable members in favour, please say aye. Those against, please say no. Methinks the ayes have it.
Mr. Speaker, I beg to move that this resolution now be agreed to.
The question is that this resolution be now agreed to. All those honourable members in favour, please say aye. Aye. Those against, please say no. Methinks the ayes have it.
Mr. Speaker, I beg to move the suspension of this sitting until 5 p.m.
The question is that this honourable chamber be suspended until 5 p.m. All those honourable members in favour, please say aye. Those against, please say no. Methinks the ayes have it. This honourable chamber stands suspended until 5 p.m.